Commonwealth Affairs.
Mr. Swift.
My Lord.
Sorry, starting a bit late. We had a bit of an electronic hiccup.
Yes, no, we
You probably witnessed. Yes, very well.
My Lord, may I start just by coming back to a couple of matters that were raised by my Lord, Lord Mance, at the end of yesterday afternoon?
Yes, you may.
My Lord, there were, I think, three practical points. The first was in relation to Security Council voting, and my Lord, I can confirm the Wikipedia entry in that the rule is that there should be 9 votes in favour and no vetoes, and so as silence does not amount to a veto.
Right.
My Lord, in relation to the 1267 committee, the first question put was whether the final decision to add Mr. Youssef to the consolidated list was taken in an actual meeting or via the written procedure. Yep. It's difficult to be absolutely certain at this remove, but it appears that Mr. Youssef's listing was effected when the committee members who had placed holds on the proposal lifted those holds, and that would have been done by a written procedure. And
would there have been an earlier meeting at the stage when the thing was originally introduced? I mean, when the holds were in effect placed?
My Lord, yes, that's the next point. Again, it appears that in general, in 2005, the way in which proposals were dealt with is that the proposals were circulated in writing by the chairman of the committee, ordinarily under the procedure referred to at paragraph 9b of the note of procedure that you saw yesterday, which is volume 8, tab 67. You don't need to go to that now. What that provided was that the proposal would be circulated, and there would then be a 2-day period for objections to be raised or holds to be placed. In the absence of objection or hold, the proposal would be regarded as adopted. A decision would be taken.
So that stage was dealt with in writing too?
Indeed. And so that was the general procedure in 2005. So far as concerns what happened in Mr. Youssef's particular case, again, difficult to be absolutely certain, but so far as I can get instructions at this stage, it appears that Mr. Youssef's listing was done in that usual way for 2005. And so by that process of circulation of the proposal, a 2-day waiting period, and then in the absence of objection or hold, the listing would take effect. My Lord, those are the 3 practical points that were raised. My Lord, you also mentioned the judgment of the House of Lords in Rayner and Department of Trade and Industry. You have a small pack of additional documents at the front of your desks. Let me just tell you, by way of list, what you have there, and I'll go to some of them very briefly. The first is an article in the LQR for 2008 by Philip Sales and Joanne Clement.
Oh, thank you. Oh, this is a small bundle, I see.
Yes.
I hate to think what a large bundle would look like.
I should say the larger part of it is Rayner and DTI.
Well, I thought I said we didn't need to copy the whole thing. Well, have we not got the whole thing? We've got to.
You have got.
We have got the whole thing.
Yes. In the time available, it was easier to do the whole thing and then just give you 2 short references than to do the. It's the usual thing. It takes more time to write a short letter than a long letter.
And more trees are cut down and so on.
And no idea of using 2 sides of the page.
Right.
Well, they'd only have been copied on alternate pages if that had happened.
Yes.
Anyway, it's a pleasure to see a case
but you have
lasted 26 days in the House of Lords.
Yes.
Okay.
Yes, and you'll see that I think.
Anyway, what do you want us to refer us to?
Firstly, let me tell you what you have. You have the LQ article.
Yes, we can see what we've got.
The judgment of the Divisional Court in C&D and Prime Minister.
Yes.
Rayner and DTI, and then recur.
Yeah, we can see that. What do you want us to look at?
The upshot of all of this, and I'll take you in a moment to brief passages in the article and to the judgment of the C&D case, is that the submission I made yesterday, which is that you should exercise caution before ruling on the extent of the obligations of the members of the committee, I say is confirmed by these materials.
Thank you.
Firstly, can I take you to the LQR article between pages 394 and 400?
Right, thank you. Yes.
That's the section of the article that deals with unincorporated treaties. You see the heading in italics in the middle of the page. Over the page, 395, side heading non-justiciability.
Yes.
There's a reference first to the International Tin Council case, and then reference to the judgment of the Divisional Court in the CND and Prime Minister case.
Yes.
If you go towards the bottom of page 395, 6 lines from the bottom, towards the left-hand margin, the sentence starts, if there is no point of reference. And I'll read this passage. If there is no point of reference in domestic law to which the international law issue can be said to go, the courts will not examine the international instrument. The domestic courts do not have the responsibility or authority at the international level for interpreting and applying international instruments, and there is a real risk of them reaching conclusions that would not be accepted by those international organs, which are in fact given that responsibility. This suggests domestic courts should proceed with caution and only venture to give rulings on the meaning and application of such instruments if there is some compelling reason of domestic law that requires them to do so.
Yes.
And then the next paragraph refers to, again, caution by reason of other matters arising in the public interest, but I don't read that. While you have that article in front of you, could I also just ask you to note what is said on page 3, between 397 and 398, as to the absence of direct effect of...
Can I just, in relation to the passage you just read?
Yes.
This is about the need for a domestic foothold.
Yes.
Is a sufficient domestic foothold supplied by the fact that a reviewable decision is involved, reviewable, that is, at the suit of a person who satisfies the ordinary rules about standing?
My Lord, I say that in the present case, and I'll make this good by reference to the judgment in the CND case.
Is that right?
In principle, yes, if you are of the view that that provides the necessary compelling reason to rule on the provisions that govern the proceedings of the committee.
I get the impression you want to deal with this after you've taken us through the various documents. Is that right?
I'd like to take you to the judgment in CND.
Okay. Now, is there anything else you want us to look at in the LQR?
The LQR, just really for your notes at this stage, my Lord, it's the passage under the heading no direct effect from 397 until 398. That is... it makes points that will be relevant when I get to the submission on the NTIC and Carrington submission.
Very well.
The CND judgment.
That's the next thing you want us to look at now.
My Lord, yes. The relevant paragraphs in the judgment of Lord Justice Simon Brown, it's paragraphs 36 to 40.
Thank you.
Again, should you need to...
Is there anything in particular you want us to read at this stage there? Do you want us to read the whole thing, or do you want us to read, or can we do that later? Or is there any particular thing you want to draw to our attention?
Is this not completely reported?
So far as I can find, no, it's not. I could only find a transcript on Westlaw. The paragraph 36, my Lord, is ultimately reflected in the summary passage that you've seen in the article in the LQR. Paragraphs 38 and 39 go slightly further in that they refer, in addition to a general rule in the interests of comity. Judge says there, the general rule is that in the interest of comity, domestic courts do not rule on questions of international law which affect foreign states, and then quotation from Buchan Attorney General, and similar a quotation to similar effect in the Lake Railways case, Lord Diplock's speech. And then paragraph 40, I would notice too in this connection, the reference in paragraph 57 of the court's judgment in Abbasi to the court exercising caution when faced with an allegation that a foreign state is in breach of international law. Whilst the statutory context within which Aden was decided necessarily defeated the Crown's case on comity there, plainly that is not so here. Here, there is simply no foothold in domestic law. And then there would need to be compelling reason for the court to take the unprecedented step of assuming jurisdiction here, and no good reason not to. In fact, the opposite is the case. Coming to the present appeal, my Lord, I say that if one approaches Mr. Youssef's first submission That is to say that the Secretary of State endorsed a decision of the committee that was obtained based on torture obtained evidence. If you approach that simply, as my Lord Newberger, you suggested to me yesterday, from the point of view of the Foreign Secretary as a matter of fact, based on my submissions of yesterday, the Foreign Secretary is not to have been taken to have endorsed any such basis for the decision. If you approach the matter on that basis, there is no need, for the purposes of resolving this appeal, to address the meaning and effect of the Security Council resolution or the document that sets out the procedures for the committee. And so, in those circumstances, I say that in this appeal there is, in fact, no compelling reason for this court taking the step of construing those documents.
Yes, I see.
However, of course, if you are against me on that submission, if looking at it from the point of view of the Foreign Secretary, you are not satisfied that he did not associate himself in the way that Mr. Youssef says he did, in those circumstances, I say you should look to Resolution 1617. You should also look to the procedures document I took you to yesterday. And I say that if you do that, the conclusion that emerges, again, is that there was no obligation for the committee to state reasons. There is no provision for any formal statement of reasons. The provisions in Resolution 1617, those are paragraphs 4 and 6, are referring only to reasons being provided by the proposing state.
No,
so if you need to construe the UN documentation, the proper conclusion to reach from that, again, is that there is no basis for Mr. Youssef's first submission that the Secretary of State is in some way associated with the decision of the committee, which was based on torture obtained evidence.
Thank you.
So, my Lord, that's the submission arising of those documents. I've given you the Tin Council case primarily because it was the case that my Lord Mance referred to. In fact, there are two short references in the Tin Council case. I'll tell you what they are rather than take you to them. It's page 476G and then page 499E to 500D. And the material part of the head note is the first finding of the court, which
Yes.
in the report you have, I think it's page 420.
It is.
Or between E and D. But I don't for a moment invite you to read that judgment.
Now, are you relying on this, and if so, in connection with all the points that are raised by Mr. Otti, or some of them, or one of them, or are you not relying on this?
Tin Council, my
Yeah.
Lord. Tin Council, I say that doesn't really add a great deal. I say that you get all that you need from the judgment of the Divisional Court in the C&D case, which actually is dealing with a matter, a point that is more directly an issue in this appeal than the points that were an issue in the Tin Council.
Thank you. But nonetheless, for what it's worth, you're taking this, and then you wanted to go to the beginning of Lord Templeman's speech. Is that right?
Yes.
You said 476.
It's the passage on 476 at H.
Yes, I see.
He sets out general, obviously,
Well, the normal dualist principle,
indeed.
Yep.
And similarly, and it's Lord Oliver's speech on 499, under the heading "The Principle of Non-Justiciability." 499
yes.
E to 500D. Again, it is
Well, of course.
the principles that arise from the dualist approach.
Yes, I see.
So, my Lord, those...
So what
That's a
about
slightly
the
different point from
sentence-
the
I'm
dualist
sorry.
approach.
What about the sentence of Lord Oliver between B and C on page 500, Tin Council?
Yeah.
The royal prerogative, while it embraces the making of treaties, does not extend to altering the law or conferring rights upon individuals or depriving individuals of rights which they enjoy in domestic law without the intervention of Parliament.
Yeah, I don't dispute that, my Lord. Clearly, that is a point that goes to Mr. Otti's submission on Entick and Carrington. But it's no part of my submission that proposition is wrong.
Yes, very well. Thank you.
My Lord, may I go now to the second part of the first ground of appeal?
Is McCurr intended for some later proposition.
My Lord, McCurr, I give to you out of an abundance of caution. In the article,
It refers to McCurr, yeah.
refers to McCurr, and the point that is made by reference to McCurr, and this is at page 398.
Is this Lord Steyne?
It is,
Thesis?
yes. Yes. And the point that Lord Steyne, the general proposition that Lord Steyne makes, is that the usual principle of caution may be slightly, the strength of that may be slightly reduced in cases where the claim before the court is based on the assertion of a fundamental right.
That hasn't so far attracted
No.
No.
majority assent. Lady Hale and I think, were attracted to it in a case called Hurst, ex-parte Hurst.
But I give that to you simply because it's referred to in the article. I think it is probably, it's fair that I give that to you as well. So, my Lord, the second part of the submission on the first ground of appeal, that the Foreign Secretary was required as a matter of legal obligation to ensure that the members of the 1267 Committee did not rely on the material provided by Egypt. My response to that submission, in a nutshell, is that the international law obligation asserted by Mr. Youssef is not made out. Now, there is no dispute in this appeal as to the importance of the prohibition against torture. That's the obligation at Article 2 of the Convention Against Torture. There is also no dispute that under the Convention Against Torture, in addition to the Article 2 obligation, there is also an obligation on states not to use material that is the product of torture that has been torture applied by some other state. And the relevant obligations under the Convention are Articles 12 and 15. And they are set out in the speech of Lord Bingham in A number 2. If I could ask you to turn to that. A number 2 is in Authorities Volume 1, Tab 1. And the relevant page is MS page 1180.
Yes.
And you see...
We've been taken to this. Yep.
Yes. Article 12 set out, and then Article 15 set out as well in relation to reliance on torture obtained material. However, what is in issue in this appeal is whether there is an obligation for one state to intervene in the business of another state, not in respect of the Article 2 prohibition, but rather to insist that a state does not rely, for the purposes of its own decision-making, on information, in this case, put forward by Egypt.
I think Scotty would say that's putting it a little bit high. All he says is that the UK representative shouldn't have voted in favour. He shouldn't have done. He should have got anybody else to stop doing it. I'm not saying he's right, but I think he'd say you're putting it a bit high.
Well, again,
No obligation to proselytise.
No.
Obligation to exercise self-restraint.
this, I think, starts to tease out the problem in Mr. Otti's submission. If there is an obligation, how do you formulate it? My Lord, you would have seen at paragraph paragraph 95 of our Skeleton Argument in the core volume at it's page MS 157. We, just by way of example, set out a series of points that would be relevant.
So do you say if all the other members, they'd attended a meeting, all the other members said, well, we think that all this evidence was obtained by torture, we don't care, we're voting for it. What then? Should the Foreign Secretary have said, well, in light of that, I don't think we should be deciding this case on the basis of what you think is tortured evidence. I'm not going to say anything, but I'm simply not going to vote in favour. I know you say primarily that he had no reason to know, which seems to me to be a pretty simple and powerful point, but never mind.
But I need to address that answer from the basis of the existence or not of a legal obligation, rather than what, as a matter of general politics, the Foreign Secretary would have said in that situation. Simply as a matter of legal obligation, and I make this submission by reference to the judgment of the Court of Appeal in Bingham, there is no sufficiently clear legal obligation, and that a person in the position of the Foreign Secretary, in the example you put to me, is actually required to intervene in that way. I say nothing as to what he would actually have done in practice.
No, I appreciate that it's putting the facts far more against you than they are, according to your case. I quite see that.
But from the point of view of legal obligation, rather than moral or political obligation, there is no such
Well, we're
obligation.
entitled to test, I suppose, the existence of a legal obligation against the, in the light of the practical world.
Yes.
I mean, if the legal obligation is simply to refrain, the reality is that it would be extraordinary for the Foreign Secretary to stop there in practice. Yes. I mean, say, I'm sorry, I'm not going to vote. I'm not going to explain why. The reality is that in an international organisation, he'd be asked, well, why aren't you voting? And he'd have to explain. And he'd have to say, well, I'm explaining because I think you chaps have got it all wrong. You're relying on torture-based evidence, and unless you change your mind and persuade me that you're not relying on it, I won't be able to vote in favour. That's the practical reality. And we have to assess whether... I mean, there's no one suggests, at least I don't think it's suggested he had an obligation to proselytise, but in reality, if there is an obligation not to withhold the vote, he would end up proselytising, or if he was going to be...
What he would end up saying, surely, is there are, on facts comparable to this case, is there are perfectly good reasons which have nothing to do with torture for listing this person. And those are the ones that you should be adopting. Those are the ones that I think are persuasive.
Yes. But
the next question is, do you have an obligation, if you are a UK representative there, acting on the instructions of the Foreign Secretary, to refrain from supporting a listing for perfectly good reasons, simply because you think that everybody else is doing so for bad reasons?
Yes. Yep. Indeed, but also you might not get to that point as quickly as you would think. If you recall A number 2...
sooner or later.
Yes, but if you recall A number 2, and the issue before the court then as to could torture-obtained evidence be relied on before SIAC, the starting point is that if there is reason to believe that evidence may have been obtained by torture, the first obligation is an obligation to investigate, to find out whether in fact that is torture-obtained whether you can establish that it is torture-obtained evidence or not. It's only once you've investigated and come up with an answer, or you've investigated and failed to reach an answer.
The problem in the SIAC's sort of case is that in most of them, there's no alternative basis for making the same decision. If the question is, for instance, whether somebody should be deported to a country where torture prevails, or extradited on evidence which is torture-tainted, there isn't an alternative basis. But here we are concerned with a quite different situation.
Well, yes, but sorry, the point I'm making is in terms of trying to identify what the legal obligation would be, if one looks at the way in which other established international law obligations are framed, one could anticipate that in this situation, present situation, the first matter would be for the Secretary of State, for there to be some sort of inquiry to establish whether or not the information that the Secretary of State was impugning was in fact obtained by torture or may have been obtained by torture.
Yes, Mr. Swift, I think I'm duty-bound to remind you that you've been going now for well over an hour and we're still on the torture point. It's a matter for you, but I don't know whether there's anything you want to add on that aspect. There's another 3 points at least to get through.
My Lord, can I do this? Could I take you to the judgment in Bingham?
Yes.
Because I think that makes good the point as to the absence of any legal obligation that is asserted in this case. Bingham is in volume 3 of the authorities.
Very well.
At tab 20.
Yep.
The relevant passage in the judgment, I'm sorry, it's Divisional Court, not Court of Appeal, starts at paragraph 170 on MS page 2230.
Thank you.
You will see that from 170 there is a review of the case law, which is largely the same case law as reviewed by Lord Bingham in his speech in A number 2.
Thank you.
Including the Furunzia case. Paragraph 177 and 178, I say, are particularly an issue here. They are on page MS 2235. I won't, but I'm asked to draw your attention to 166. In the interest of time, I won't read it.
Okay, well, we have that. Thank you. Mark it, yeah.
Paragraph 177 is that in the present case, the Foreign Secretary places particular reliance on these passages and submits the Court of Appeal's conclusion that the status of jus coga erga omnes empowers but does not oblige a state to intervene with another sovereign state to insist on respect for the prohibition of torture, provides a complete answer to BM's argument on international law. By contrast, BM submits the reasoning Court of Appeal in Al-Rawi's case is inconsistent with A number 2. For the reasons stated elsewhere in Al-Rawi's case and in Abbasi, there was no obligation on the United Kingdom in international law to make diplomatic representations to the US government in the circumstances of those cases. However, it may perhaps be doubted whether an obligation to act on the international plane to vindicate the rule against torture could never arise in international law. The erga omnes character of the rule against torture is addressed in Prosecutor and Furenzia, on which Lord Justice Laws relies for the proposition that the status of jus cogens erga omnes empowers but does not oblige a state to intervene. Next sentence, it demonstrates that the duty is owed to all states, which therefore have a correlative right to require compliance. The tribunal was not there addressing the question whether a state may be required to take action to ensure respect for and compliance with the prohibition on torture. Moreover, we've seen that the International Law Commission draft articles on state responsibility would impose a positive duty on states to cooperate.
Yeah, but all this brings one back to the argument we've just been having, whether by not voting, that is simply exercising your own right and power and duty, or whether it goes further than that and falls within the exception. So
Indeed,
it comes back to what you were discussing with Lord Sumption and Lord Mann.
Indeed, and my Lord, it makes the point in my submission very powerfully that there is no sufficient degree of certainty as to the existence of the obligation that Mr. Otti asserts exists. Even as at 2009, when Binion's case was decided, one sees uncertainty arising from the consequences of the judgment in Furenzia, uncertainty arising from the proposals put forward in draft by the International Law Commission. And so on that basis, one cannot assert the conclusion that in this case, the Foreign Secretary was under a legal obligation to intervene in the way that it's suggested. My Lord, may I also just ask you to note the passage in our skeleton argument from paragraph 90, it's MS 153. What we address there is the difference of opinion between the special rapporteur and the ombudsperson as to the basis on which evidence that may have been obtained by torture should be excluded or not from listing decisions. Now, true it is that ultimately each of them reaches the same practical...
Which paragraph?
It's paragraph 90 of the...
I'm sorry. Yeah, I thought you said 153. Paragraph 90. Thank you very much. Yes, I see. Thank you.
True it is
yes,
that
indeed.
they ultimately reach the same practical conclusion that no reliance should be placed on such information, but they do so by a significantly different route. The special rapporteur reaches that conclusion on the basis of the existence of a legal obligation, the ombudsperson on the basis of a pragmatic approach.
Yes.
The fact that, I say, further demonstrates the absence of the necessary agreement for the purposes of customary international law, not only as to the practice, but also as to the practice being pursuant to an understood legal obligation. So in those circumstances, my Lord, I say that there is no relevant obligation on the Foreign Secretary. May I move now to the second issue, which is the Entick and Carrington issue?
Yes.
My Lord, there are three submissions I make in relation to this, and I work backwards from the principle in Entick and Carrington, so starting with the principle in that case. The first submission is that Entick itself was not a case where the question was, had there been an interference? There plainly had. There had been a search. Rather, the issue in Entick was whether there was a legal basis for that interference. You have the report of the judgment in Volume 2 of the authorities at tab 8. I won't spend time taking you through that in detail, but may I give you just a few signposts in relation to that judgment. The first part of the judgment addresses the question of whether the Secretary of State, who had issued the warrant, did so because he had powers equivalent to those of a magistrate. the conclusion being that he did not. It's paragraphs 1046 to, columns 1046 to 1059 in the report. The next question the court addresses is whether the Secretary of State had any relevant power to act because of the fact he was a Privy Councillor. And again, the answer to that question was no. There was no relevant power arising from that status. There was then a final question as to whether the Secretary of State had any power to issue a warrant arising from necessity. And again, that proposition was rejected as well. And again, that's the passage from column 1063.
Yeah.
What you get from Entick and Carrington, that the issue that the court was concerned with was the existence or not of a legal basis for the interference with property rights. And so my primary submission in this appeal on this point is that Entick and Carrington is not concerned with questions of remoteness, i.e. how distant was the decision of the Foreign Secretary from the application of sanctions.
Well, it was as direct as it could possibly be. He told them to do it.
Yes.
In Entick, yes. That's true. But it's not a question about remoteness. It's a question about, is there legal authority for the interference? In this case, the inquiry as to what was the legal basis for the interference with Mr. Youssef's rights begins and ends with Regulation 881. Could I ask you to look at Regulation 881, which is in Volume 8 at tab 64? If you turn to the second page of the regulation, which is MS page 3439, you see there at Article 2 the relevant...
343.
9, my lord.
Yep. Article 2.
Article 2 identifies the asset freeze and the prohibition on the provision of assets. So those are the relevant measures of restraint. Article 7, and so I should say Article 2 makes it clear that those measures are applied to people who are listed in Annex 1 to the regulation. Article 7 on the facing page then gives the Commission the power to add names to Annex 1 on the basis of determinations made either by the United Nations Security Council or the Sanctions Committee. And so one sees that the legal basis for the let me take a step back. The thing that interfered, the measure that interfered with Mr. Youssef's rights was the application to him of Regulation 881. That occurred because of the Commission's decision under Article 7. And at the next tab, tab 65, tab 66, you see the Commission decision that actually applied the regulation to Mr. Youssef. The Commission took that decision in exercise of its power under Article 7, and the authority for the Commission to do that by reason of the provisions of Article 7 was the decision of the Sanctions Committee, not the decision of the Secretary of State. And so in those circumstances, the only question, rather the answer to the only question that Entick and Carrington poses is that the basis of the authority for the interference of Mr. Youssef's rights is Regulation 881.
But you have to state further how it becomes law in this country, which presumably is the Communities Act.
Well, the regulation itself, by reason of the European Communities Act, is directly effective in this country.
Yes, but I mean that's an important stage because that is the UK parliamentary authority which gives effect to the European decision.
Indeed, my lord. And for completeness' sake, I should also say that in addition to the regulation itself, under the power to make secondary legislation under the European Communities Act, an instrument was made that provides some sort of, it provides enforcement mechanisms for breaches of the regulation. So, for example, criminal penalties for those who act in breach of the restrictions.
So is that a UK regulation?
That is a UK statutory.
Where do we find that?
I don't believe you have that in the bundle. But well, it's part of the usual way in which regulations are given effect, in the sense that you can see Article 10 of the regulation requires each member state to determine the sanctions to be imposed that are to be effective, proportionate and dissuasive. And so, pursuant to that obligation, the remedial provisions were made via the power to make statutory instruments under Section 2 of the European Communities Act.
They're at tabs 41 and 42 of Volume 6.
Oh, I'm grateful.
Volume 6, 41, 42.
Yes.
Thank you, Mr. Otti. Yes.
Yes. So you see that they establish offences or breaches of the prohibition. They establish a power at Regulation 7 for the Treasury to grant a licence by way of derogation from the prohibitions in Regulation 881. They deal with corporate liability and other matters within a similar vein.
And the varies of those have never been questioned.
No.
Yes, that answers a question that I was going to ask. This is what happened after Ahmed in the Supreme Court.
Quite so.
Right?
Yes.
At least the first.
Yes.
Now, is your... Because, of course, he was already
Yes.
frozen for 5 years before this statutory instrument in April
Yes.
2010. Is it your case that without this statutory instrument, he was still frozen under European law because of the direct effect of the regulation?
Yes, he was, yes. But in any event, Mr. Youssef has already won that other case. He can't win this case just because he won the other one.
That's a different point.
I lost that one in 2010.
No, I think I'm not quite sure that was the point I was making, but it doesn't matter.
So, my lord, that is my first submission in response to the Entick and Carrington ground of appeal. The second point follows from that primary submission.
Does the regulation we've just been looking at,
Yes.
is that only concerned with criminal offences committed by third parties who deal with the assets of a designated person, or does it apply also to the acts of the designated person himself?
It applies also to the designated person.
Thank you. Right.
But yes, in any event, just perhaps to give a more reasoned answer to my Lord Mance's question, by reason of Regulation 881, from the time of the Commission decision that added Mr. Youssef's name to Annex 1 in 2005, he was subject to the prohibitions in Article 2, and on that basis, the interference with his property rights and other rights arising from those prohibitions was effective from that time. So, as I say, my second submission follows from the primary submission and is in response to Mr. Otti's reliance on the secondary liability principle, the judgments in Davidson and M against Hackney. This submission is that principle has no application in the present context, primarily for the reasons I've just given. That is to say, the only issue that is raised in this appeal is whether there was a legal basis for the interference of Mr. Youssef's rights. The secondary liability principle is, as its name suggests, a principle about liability rather than about legal authority. And so it is simply something that has no bearing on the issue in this appeal. Put another way, if Mr. Youssef is right, one could see that even if a Secretary of State now applied for a search warrant and got one, on Mr. Otti's argument, one could still challenge on the basis of the Entick argument the Secretary of State's prior decision to apply for the warrant. It was said, well, that was, the Secretary of State made that decision in fully intending to make the application and fully hoping that it would be granted. On that basis, it's a matter of simple causation. there was no legal basis for the Foreign Secretary's decision, even though the warrant, the actual thing that authorised the interference with the person's rights, would have been issued on a proper legal basis. So I think that point demonstrates also that secondary liability has nothing to do with the issue in this appeal. The third submission, which is my alternative submission, is that even if you accept the premise of Mr. Youssef's argument that all that is an issue here is an issue of proximity or causation, the argument still fails because it is clear that the decision of the Foreign Secretary alone, the decision in issue in these proceedings, was incapable of resulting in any interference with Mr. Youssef's rights. Again, the cause of the interference, one looks to the Commission's decision, one then looks to Article 7 of the regulation, and one sees that Article 7 authorised the Commission to act only on the authority of a decision of the 1267 Committee. And so it was only on the basis of that authority that the interference could occur. And so even as a matter of simple causation or proximity, one sees that that decision by the committee is the relevant starting point, not the positions taken by individual members of the committee prior to the decision of the committee. Looking at another way, in this case, we know that the Foreign Secretary was one of the last members of the committee to agree to the proposal. The sequence of events was proposal in March, hold placed by 2 states, Foreign Secretary releases his hold in September, a week or so later.
By 3 states, including the UK.
Yes. So he was one of the final people to decide. Well, what if the timing had been different? Say the proposal had been made and the Foreign Secretary was the first person to agree to it, and it was only a few months later that another state that that had added a hold, released that hold.
But
should that make a
proposition
difference?
strikes one as a little questionable. If you all agree, none of you is responsible.
Yes.
Well, the committee is responsible.
But if two people, I mean, forgetting the special facts of this case, if 2 people are responsible for something, you can't say neither is responsible.
Yes.
I mean, I see your other points, but this...
Again, it comes... My Lord, one can only address this argument by reference to the relevant legal instruments.
Well, I see all that. All I'm saying is that I think putting it in terms of a general proposition is about 2 people or a group of people is not quite the point.
Well, that is the way I put it.
By reference to the facts of this case and the legislation and so on, that I understand.
Yes, it is by reference to what Article 7 of the regulation allowed the Commission to do, and that was only on the authority of a decision of the committee, not on the say-so of any single or more members of the committee. So, my Lord, for those reasons, I say that the second ground of appeal also fails. Could I turn now to the third ground of appeal, which is the question of standard of proof that should have been applied by the Secretary of State? My Lord, my submission is that any issue, any dispute as to what was the question the Foreign Secretary should have asked himself when deciding whether or not to agree to a designation ought to be determined by reference to whether the approach that the Foreign Secretary took was consistent with the decisions of the Security Council which set the criteria to be applied by the 1267 Committee. The decision that the Foreign Secretary was taking was a decision on how to act as a member of that committee, and so the standard of proof, or the question he should have put to himself, must be consistent with the obligations on the members of that committee when they add people to the consolidated list. So, well, that I say should be the starting point and the basis of principle on which to decide whether, in this case, the Secretary of State acted correctly, was permitted to approach the issue by reference to whether or not there were reasonable grounds to suspect that Mr. Youssef was associated with Al-Qaeda. By reference to the Security Council's approach to the basis of designation, I say that there are three matters which cumulatively make good the conclusion that this reasonable suspicion approach was an approach the Foreign Secretary was entitled to adopt. Now, I say entitled to adopt because the relevant issue, the relevant question, should be whether the approach the Foreign Secretary adopted was consistent with the requirements identified by the Security Council. It is clear that the Security Council itself had not, as at 2005, prescribed any single formulation. And for that reason, my submission is, and I say needs to be no more, than that the approach that the Foreign Secretary took in this case was consistent with the approach that can be discerned from the Security Council's resolutions. So, as I say, there are three matters that I say collectively make good the Secretary of State's approach. To list them to start with, the first is that the Security Council had identified the measures in Resolution 1617 to be preventative measures. The second is that the Security Council had urged member states to give effect to the approach set out by the Financial Action Task Force. And the third matter is slightly after the event, but it is that the position now adopted by the Ombudsperson, and adopted since 2011 as to the standard to be applied, is entirely consistent with the conclusion that the Foreign Secretary's reasonable suspicion standard was a permissible option for him. And that, for that proposition, I'll rely on the statements that the Ombudsperson has published between January 2011 and January 2013. So taking each of those in turn, first, the Security Council stated that the measures were intended to be preventative. That is clear from Resolution 1617. Just to take you to that for a moment, that's in Volume 7 at tab 49, if you would be so good as to turn it up.
Tab 49.
Please, my Lord.
Thank you. Yes.
And two reference points. The first within the preamble, page 3278. The first paragraph starting on that page, underscoring the importance of member state designations pursuant to relevant resolutions and robust implementation of existing measures as a significant preventative measure in combating terrorist activity.
So where do we find this? It's the
At the top.
3278, it's the first paragraph starting on that page with the word underscoring. Sorry, my Lord, the second page of the resolution.
Oh.
So that identifies in the preamble the preventative nature of the measures. And then paragraph 7 of the resolution itself.
Yes. Yeah.
Again, urges all members to implement comprehensive international standards embodied by the FATF's 40. Sorry, No, sorry, I was getting ahead of myself. Sorry, the preamble identifies the preventative nature of the measures. And, my Lord, just for your reference, that is a consistent theme of the resolutions passed by the Security Council within this series of resolutions. Can I give you two other references to subsequent...
Very obvious that's what it's about.
Well, yes.
And what else would it be for?
The only consequence of it
It's
is
fairly obvious that that's what it's about. But does it follow that the general object is to prevent resources being used for terrorism, that the criterion to be adopted by the Secretary of State should be as low as reasonable suspicion?
Well, my Lord, it's certainly consistent with that conclusion, And that is for the reasons stated by Lord Justice Laws in the Court of Appeal. It's paragraph 32 of his judgment. The point he makes there, I don't think it's necessary to turn up the judgment for these purposes, is simply that because the aim of the regime is a preventative aim, it is plainly more effectively promoted by the adoption of a reasonable suspicion standard.
Well, the trouble about a reasonable suspicion standard is it's not a single standard. It could be a variety of standards. I mean, suspicion can range from anything to, well, it might be so, to it quite probably is so, and therefore it just depends on what one regards as reasonable in the particular context. I mean, it's at one extreme, it's not a particularly low standard. At the other extreme, it's a very low standard.
Yes, and well, as a matter of practice, if the issue in this appeal was whether in fact there was a reasonable basis for the suspicion, then a court on an application for judicial review would consider whether that was so or not. And you will have seen from the divisional court's judgment that when that was an issue, the court itself was able to test which end of the scale of reasonable suspicion this decision was, and on that basis to decide whether it had been a lawful decision by the Secretary of State. So I take my Lord's point that there is a range within the notion of reasonable suspicion, but that point is properly addressed by the way in which a court on an application for judicial review scrutinises the actual reasons for the decision.
Is there a threshold to this point before we get to it? I mean, if you're right on your second and your first point, is this a point where there's any foothold in domestic law?
I'd say there doesn't need to be, because the question that is raised by this ground of appeal is effectively it's a relevance question. Did the Secretary of State ask himself the right question when deciding what to do? I say the answer to that matter depends on, depends on firstly the fact that the Secretary of State was asking himself what to do as a member of this committee. Yeah. And so the question he had to ask himself had to be one that was consistent with the basis on which members of the committee were required to act.
That's why I asked whether there's a sufficient domestic foothold. If this is really a basis which was adopted by the committee, and as you say, it might have been rather difficult for the Secretary of State to adopt any other basis. Anyway, we can consider that separately, but I carry on.
But for the purposes of the English law analysis, I say the proper approach is by way of effectively the inquiry as to relevant considerations. It is relevant for the reasons that what is relevant is identified by the Security Council decisions for the reasons I've given. In this case, one theme is the preventative nature of the measures, which is consistent with a lower rather than a higher standard of proof, because that would tend to make the preventative regime more effective as a preventative regime.
My question was really this. How do we differentiate this from any vote in the Security Council? Is it open to a domestic court to review any minister's vote in the Security Council and consider whether it's compatible with international law insofar as he's made representations or expressed attitudes?
I think the answer to that question must be no.
Well, how do we distinguish the present case?
Yes. In terms of, I appreciate I'm arguing against myself here, but I suggest that the analysis should be this. The challenge to the Foreign Secretary's decision as to what to do as a member of the committee should be regarded as a complaint that the Secretary of State took into account an irrelevant consideration, namely the reasonable suspicion standard. So effectively was doing something that was unlawful. In order to identify whether that challenge is made good or not, one needs to look to the practice established by the Security Council resolutions. This comes back to the point identified in the CND judgment and in the Sales Clement article in the LQR I took you to at the beginning of this morning. That is to say, firstly, is there a domestic complaint that engages the need to look at the international law position at all? In this case, the answer to that question is probably yes, because one has a challenge to an actual decision taken by the Foreign Secretary. Is there a compelling reason for this court to address the matter? Well, I can see that the existence or not of a compelling reason is something that is eminently debatable, but for the moment, assuming that one doesn't rule out the challenge itself as being simply non-justiciable, one has to assess the Foreign Secretary's approach to this decision on some basis, and because what he was doing was a decision as to how he should act as a member of this committee, the only rational and relevant basis to choose is the standard that would be applied by members of that committee when they were taking the actual decision to designate somebody or not. So, as I say, it's always been the Secretary of State's case from before the hearing in Ahmed, in fact, throughout that litigation, that if there had been a prior decision by a Secretary of State to take a particular stance in respect of a proposal before the 1267 committee, that decision was in principle a reviewable decision. I accept that position taken by the Secretary of State puts this case on the edge of the area of domestic law that is justiciable by this court. But nevertheless, it's always been the Secretary of State's position that it is on the right side of that edge, and for that reason, in principle, the decision is justiciable, even though my submission is that you have to assess the legality of the position by reference to the practice of the committee. The alternative is that if you can't look at that, the alternative conclusion must be that this whole area is not justiciable, because there is no other relevant and workable standard by which you could assess the legality of what the Secretary of State did. So those are the choices, but I don't say, it's not my submission, that this ground of appeal is non-justiciable. Rather, I say it should be looked at, as I've said, by reference to the approach that Security Council has told the committee to take. So the first part of that is the preventative nature. The second part, and this is paragraph 7 of the regulation of the resolution, that is the encouragement to member states to conduct themselves in accordance with the FATF 9 special recommendations. Can I ask you to go to those recommendations? You have them separately in the document that was handed yesterday morning. You've seen Special Recommendation 3, and it's the first part of that special recommendation, which is the recommendation that states should freeze, etc., assets in accordance with Security Council resolutions. The interpretive notes to that start at page 7 of the document. Mr. Otti suggested yesterday that the Security Council can only have been taken to be referring to the recommendations, not to the interpretive notes. I say, with respect, that's a hopeless point. It's obvious that the interpretive notes are part and parcel of what the FATF was recommending.
They are published as part of the same document.
They are, yes. The relevant paragraphs are 2, 3, 5 and 6. Paragraph 2 refers to the asset freeze, etc. measures, and 4 lines from the bottom repeats the point that the intent of the first objective, which is the asset freeze and so on, is preventative,
Yes.
In relation to
I'm
scope...
sorry, what page are we looking at?
I'm sorry, small page numbers at the bottom right,
Seven.
yes. 7.
7, thank you.
It's headed interpretive note.
Yes,
Under the heading objectives is paragraph 2.
thank you, yeah.
And then under the heading scope on the same page, paragraph 3.
And what you want is based on reasonable grounds or a reasonable basis to suspect or believe that such funds could be used to finance terrorist activity.
That's right.
That's what you're relying on.
That's right, yes. And so you see that within paragraph 3. You also see it within paragraph 6.
Where do we see it in paragraph 3? What I was reading from was...
I'm sorry, paragraph 2, my lord.
Well, yes. Well, we have
Then-
that. Thank you. Yep. I see how that helps you. Yep.
Sorry, it's paragraph 2. And then
And you say something in paragraph 6 as well, do you?
paragraph 6 also, it's the last 5 lines, is put on terms of reasonable grounds, reasonable basis to suspect or believe. That's 3 lines from the bottom. Now, I need to point out to you that paragraph 6 is a paragraph that relates specifically to Resolution 1373 rather than Resolution 1267. Now, you will recall perhaps from the judgment in Ahmed, there were 2 regimes. Under the 1267 regime, the Security Council itself listed individuals, and member states were then required to give effect to that outcome. 1373 was a further and separate resolution under Chapter 7 by which the Security Council required member states to undertake their own designations and to apply their own asset freezes, etc., to persons who met the criteria of being suspected terrorists. Now, it might be said that it's significant that the reference to reasonable basis to suspect or believe comes within the paragraph on 1373 rather than the paragraph on 1267. I say there is no significance to that. It obviously comes within the paragraph on 1373 because that is the resolution by which the Security Council requires member states to take their own decisions. What is significant is that there is no possible basis for saying that on the one hand the Security Council would tell member states to take their own decisions on the basis of reasonable suspicion, but at the same time take its decisions under Resolution 1267 on some other basis. And so I say, that, again, this is strong support for the conclusion that the evidential basis that was required to be applied by the committee is consistent, or rather was, the basis stated here by the FATF in terms of reasonable grounds, reasonable basis to suspect or believe.
All the last sentence is doing under 1373 is making clear that a receiving jurisdiction must apply its own mind.
Yes.
And naturally, by reference to the basic test, which has been set out in paragraph 2.
Yes. And so,
Mr. Swift, paragraph 6 then, correct me if I'm wrong, is dealing with what became in the UK the terrorism order.
correct, my lord, yes. That's right, yes.
Now, correct me if I'm wrong, the Supreme Court in Ahmed said that the reasonable suspicion test incorporated in the terrorism order was too low because of the drastic consequences of designation or registration or whatever it might be. And presumably they said that notwithstanding paragraph 6, which was the steer that a criterion as low as reasonable suspicion could be adopted.
Yes. And
So what do you say about that? And more broadly, what do you say about the fact that in Ahmed, this court decided that a reasonable, albeit in the context of the terrorism order, a reasonable suspicion criterion was unlawful in the absence of express parliamentary authorization by that court. It's the terrorism order.
Yes.
But the argument is we should transpose that to this situation.
Well, my lord, my submission on that is that the reasoning in Ahmed on the terrorism order turns on the conclusion that the generally framed power at Section 1 of the United Nations Act was not a sufficiently clear and precise basis for a measure such as the terrorism order that had so drastic an impact on individual rights. And so it's not a decision that turns on a conclusion that reasonable suspicion was not what the Security Council was on about. Rather, it's a conclusion that turns on the fact that Section 1 of the United Nations Act was not regarded as a sufficiently prescriptive power to enable that sort of restriction to be imposed by secondary legislation.
But if it can't be done by legislation, in this case, how does this help you? It might be argued.
Well, because in this...
Even it might be said your argument is weaker than, at least there was some statutory basis for it in Ahmed, but here there isn't.
Well, my Lord, again, bear in mind here, the Foreign Secretary's decision in this case is not the decision that imposes the restriction.
Well, I know, but that's a different point.
Yeah, but it's an important point to have as your starting issue here. And so we're not...
If that's a good argument, you don't need this argument.
The statutory basis is the 1972 Act.
Yes.
Yes, it is.
Well, exactly, but if that's right, then...
But also, the issue of this, well, by the time we get to this ground of appeal, the issue is not the Ahmed issue about legal authority. The point instead is whether the Secretary of State, when he took his decision, applied a correct or effectively directed himself correctly or indirectly. That does not of itself turn on whether he was following an Act of Parliament or a statutory instrument. At that point, he is exercising common law powers. The question is one, as I said, of relevant or irrelevant considerations. I say the Secretary of State needed to direct himself in accordance with the approach that the committee would take, because that's what he was deciding on, how do I act as a member of this committee. And so for that reason, it is sufficient for me to make good the submission that what the Secretary of State did is consistent with the approach the committee would take. I don't need to point to legal authority for the purposes of this part of the argument. As I say, because the issue is only whether the Secretary of State took into account relevant rather than irrelevant considerations when deciding what to do. But in
the
terms
nub of it was Parliament needs to endorse a criterion as low as this. The 1946 Act wasn't good enough.
Yes.
Here you've got no parliamentary endorsement for a criterion as low as this.
Well, no, but in Ahmed, the terrorism order obviously was the thing that was the interference with property and other rights.
Well, that's your causation point. Yeah. Put that on one
it's
side.
it's not a causation point. It is the point that was the thing that interfered with the rights. And
if that's a good argument, then you don't need this one. But if you need this argument, then what's your answer to Lord Wilson's point? If you don't need this argument, fair enough on causation and other things. But if you do need this argument, what's your answer to the Ahmed point?
So I don't think I properly understood the point that's being put to me. Let me try again.
I mean, the logic of Lord Wilson's point is that this isn't binding because it's ultra vires. Can I just ask one question about the premise to the point? Come back to it. But in Ahmed, where is there a reference to the FATF 9 special recommendations, which, to my recollection, of which at present I have no recollection. Right.
It's in Lord Hope.
It may be that it... Sorry, where is there a reference?
I'm sorry, well, you have the judgment...
Would they have been relevant to Ahmed?
They were
referred to, were they?
To Ahmed.
Well, were they before us?
Sorry, because the argument in Ahmed was that Section 1 allowed steps to be taken that were necessary and expedient to give effect to a resolution. The Resolution 1373 required states to put into effect these sort of designation provisions.
Is it paragraph 59 of Lord Hope's speech?
Yes, it's 59 of Lord Hope and 173 in Lord Roger.
There's also 139 of Lord Phillips, where he refers to Resolution 1617, 2005.
Yes, it was in passages which I think Mr. Otti took us to. Yeah, I think you're right, yeah.
Let's just have the references. Paragraphs.
It's 59 in Lord Hope. I have 173 in Lord Roger.
Sorry, and 59, what is the the reference?
It's the reference there to
1320.
the evidence of Mr. Guthrie.
Yes, but were we actually shown the document?
They were exhibited to Mr. Guthrie's statement. I can't recall whether I took them to you and took you to them in submissions, but they were exhibited to the statement.
Well, I think, yes. So 59-132.
What was Lord Rogers?
173, my lord.
You see, I mean, what is interesting is in Lord Phillips, we get at 139, we get guidelines set out, but
Yeah.
that's a different thing. And
Yes, that's the committee's. That's effectively the committee's rules of procedure. That's not the FATF.
And we get another 173, United Nations International Task Force. That's
Yes.
not this, is it?
It is, yes.
That is this, is it?
That's referring to the same thing. The Financial Action Task Force, which is a
Yes, I see.
United, it's
Yes,
a
I see.
body that exists under the auspices of the United Nations.
Right.
But I mean, the question before the court was whether the fact that that was the practice adopted was in the United Nations was a good enough reason for regarding the terrorism order as being empowered by the 1946 Act.
Yes.
The question before us now is whether it was a good enough standard simply for the purposes of the United Nations Committee.
Precisely so, my
And
lord,
that's, I mean, these are different questions, and I don't see that Ahmed was deciding the latter question.
Well,
I'm not sure how it could have been deciding the latter question.
yes. That is the submission I was attempting to get to.
Well, quite, but that's exactly the point. But if that's not right, then I still don't understand what your point is on Ahmed. But
The logic
it doesn't
of
matter.
Wilson's question, surely, is that the council regulation may not be binding in the United Kingdom because it isn't empowered by the 1972 Act. And it isn't empowered by the 1972 Act because there's nothing that specifically empowers something with that kind of drastic direct effect on someone's property.
Yes.
Now, that's not a point that's been taken by Mr. Otti, but I think that that's what it may have to boil down to.
Vari's point.
Yeah.
But
Not that it's ultra varies the
No.
European institutions, though it may be for different reasons. The point is that it simply has no effect here because it's not within the enabling provisions of the Act.
yes, and not otherwise incorporated. But the issue here, as my lord says, concerns what what approach the Secretary of State was able to take when deciding what to do as a member of that committee, not what power did the Secretary of State had to impose, to take a decision that imposed a restriction on Mr. Youssef.
I mean, if the Secretary of State's decision in the UN committee is justiciable as a matter of English law, which you concede it is, then
No, the concession relates to the decision taken by the Foreign Secretary prior to his action as a member of the committee. So a decision to decide what to do as a member of the committee, rather than his.
but I mean, his decision, you can't just sort of take a decision in the abstract and judicially reviewable. It's got to be a decision having some legal effect.
Yeah.
And the only legal effect is what he does in the UN committee.
Yeah.
I mean,
Yes,
for my
my lord,
part,
that's
I have
right,
some
yes.
doubts whether that is justiciable. But assuming it is, why should it be judged by a different standard than the one that was applied in Ahmed?
Because it is a different question, a different inquiry to the one that came up in Ahmed. In Ahmed, the question was as to whether the Section 1 1946 Act power was a sufficient basis for secondary legislation that allowed restrictions to be imposed on property rights, etc.
The trouble is that why we're having such difficulty as this is the point identified by Lord Commonwealth, really. We are, if we do have jurisdiction to decide this, you say we should decide it basically according to the law of the United Nations, as it were, rather than English law. and we may think we know what this task force document says, but we have no expert evidence on what international law or the United Nations law, if that's different, would say about this.
Well, it's...
And therefore we're slightly thrown back on English law, but you say that's not really the appropriate approach, and I understand that.
Well, no,
As I understand it, what you're submitting is that
We shouldn't be.
the English law test, it can't be unlawful for the Home Secretary, for the Foreign Secretary to decide how to exercise a vote in the United Nations on the criteria which govern votes in the United Nations under the law of the United Nations.
Yes.
So you allied English and international law in that way.
yes,
Is that your submission?
that is it. That is the point. And so the Ahmed issue simply does not arise. And the point, particular reliance was placed on paragraphs 60 and 61 of Lord Hope's judgment in Ahmed. Perhaps I should just make sure you have those in front of you for this purpose. It's MS page 1320 to 1321. And there, Lord Hope is stating his final conclusions in respect to the terrorism war.
Which again, we've been taken to this,
Yes.
but yes.
The point I say that it comes across very clearly from those paragraphs is that Lord Hope's conclusion rested entirely on his view as to the scope of the power provided by Section 1 of the 1946 Act, and nothing else.
Yeah, but this was
And
a
that's-
question of entirely domestic issue,
Yes.
whereas
But-
your point is that this is an international issue, and while we apparently have jurisdiction according to your argument, nonetheless, Lord Sumption's analysis applies, and he was acting on the international stage, and therefore under UN auspices in connection with the UN decision, and therefore international law applies.
Yeah.
And the UN rules apply. Yeah.
One
As a
should
matter of
treat-
English law, I understand
One
that.
should treat this decision
Yeah, I have that.
in terms of analysis in the same way as you would treat any other decision taken by a Secretary of State in exercise of common law powers. He has to take his decision by reference to relevant rather than irrelevant considerations, has to act reasonably for a proper purpose, etc. Those basic standards. The only manageable standard that can be identified for this decision is, as Lord Sumption has stated,
It wasn't a statement by me. I was trying to
I'm sorry.
encapsulate your submission.
I was pushing my luck too far, as Lord Sumption has suggested, which is in fact the point I'm trying to get across. The only workable standard is the standard that applies to decisions taken by that committee.
Yes. Whereas we were applying, you say, in Ahmed, a different standard, namely what
Yes.
was domestically permissible under the United Nations Act.
Precisely so, my lord. Yes.
That's very well. We have the point. Thank you.
So the second of my 3 points that supports the Secretary of State's approach is the Financial Action Task Force. Can you have that? The third point is the approach taken more recently by the Ombudsperson. There are two relevant statements by her. The first is the statement she published in August 2011. I think the easiest place to find this is it was then republished as an annex to a report
Yes.
that she gave to the Security Council in 2013.
Yes, where do we find it?
Volume 8, tab 72.
Thank you. Which page do we look at?
It's MS 3561
Yeah.
and Annex 2.
And this is,
This is annexed to...
understand,
This is Miss Prost, Judge Prost. The report starts at 3537. So this is the statement that she published when she first set out how she would approach determining applications for delisting. And under the heading Approach,
yes.
Third paragraph under the heading, the Security Council has not defined separate criteria to be met for delisting. And then last line of the page, in essence, the test for delisting is the opposite of the test for listing. So that's her basic approach. Standard 3562. The paragraph that's at the bottom of that page, top of the next page, 3 lines from the bottom of the page. In order to arrive at an appropriate standard, I've looked to national and regional law and jurisprudence, particularly in the context of asset freezing or other restrictions in the counter-terrorism regimes. Could you note footnote D? She says, several states use their normal criminal or other judicial procedures. And then the 4th line, in the middle of the line, in the domestic designation of terrorist entities in a number of common law jurisdiction, a form of reasonable grounds or a basis to believe, suspect, be satisfied of involvement in or commission of terrorist acts or activities is used. Financial Action Task Force also recommends the alternatives of reasonable grounds or basis to suspect, to believe, as does the Commonwealth model legal legislative provisions on measures to combat terrorism.
Yep.
Then going back to the main text, the standard must reflect the intent of the Security Council. She refers to the preventative nature of the measures. And then she goes on to say in the same paragraph, at the same time, it must be a measure of adequate substance. The next paragraph, she concludes that a criminal standard would not be appropriate. And then the paragraph after that, at the same time, the sanctions flowing from the inclusion of in the consolidated list are of a significant nature. Last 4 lines of that paragraph, therefore, there must be some substance and reliability to the information upon which such sanctions are applied. Mere suspicion or reliance upon statements without any consideration as to the underlying information or some assessment of credibility is equally inapt. And then last paragraph on the page.
Well, the short paragraph for the last paragraph is the point really made by Lord Sumption, I think, that it's very wide circumstances. But
Yes.
then you go to the last paragraph. Yep.
Taking into account the need to balance these factors, in my view, the standard for the Ombudsperson's analysis and observations should be whether there is sufficient information to provide a reasonable and credible basis for the listing. And then sufficiency is further explained over the page. The last 3 lines of that paragraph, in my opinion, is a standard which recognises a lower threshold appropriate to preventative measures, but sets a sufficient level of protection for the rights of individuals and entities in this context.
Okay.
There is then a further exchange between the Ombudsperson and the Special Rapporteur, and we refer to this in our skirting at paragraph.
Written case, yeah. Well,
Sorry, my yes, written 133.
I
In
make
the
the same mistake sometimes.
core volume.
Yeah, 133, we got it, yep. Thank you. You set out the passages fairly fully there, don't you? Yep, thank you.
And so you see there, rejecting the rapporteur's suggestion of that a balance of probabilities test was correct. So significant, I say, the Ombudsperson does not equate her approach with that balance of probabilities. Taking those 3 matters together, I say that there is more than adequate support for the approach taken by the Secretary of State in this case in relation to reasonable suspicion.
Thank you.
And underlining the fact that...
Well, she says mere suspicion.
Yes, I think when she's talking about mere suspicion, if we read on what she says about that...
Without any consideration.
Yes, so she's not talking there about reasonable suspicion, but simple suspicion.
Yeah, I see. So
The
important word in a sense is the word mere.
Yes.
Okay.
And as I said in response to a point put to me by Lord Sumption, the reasonable is important because it's that which allows a court or an application for judicial review.
It's got to be a degree of suspicion that is reasonable, having regard to
Yes.
the implications for the person designated.
Precisely. Hence the notion of reasonable is itself a flexible issue dependent on the circumstances.
And the gravity of these
Yes.
matters that are suspected and so on. Yes. Thank
So,
you.
my Lord, that is my submission on the 3rd ground of appeal.
We're circular.
In relation to the standard of review to be applied by this court, there are 2 limbs to that submission. The first is by reference to the recent statements in this court
Yes.
as to the fact that the approach to rationality or rationality itself would benefit from adopting some of the tools of proportionality testing. I summarise, obviously, significantly the reasoning in Pham and in Kennedy. My Lord, just to address that point first, by reference to the approach that the Divisional Court took to its scrutiny of this matter, could you turn to the Divisional Court judgment, which is in Part 1 of Appendix 1?
Yep.
It is MS page 339, regular page 150. And the relevant passage,
Yep.
it's from paragraph 72.
72.
72, which is...
So it's 360, yep.
Yes, that's
Thank
right,
you.
my Lord.
Yep.
That run of paragraphs through to and including paragraph 83.
Yep.
The points that I make by reference to those paragraphs are these: that one sees that the Divisional Court firstly took account of all matters that one would expect a court to take into account if a simple proportionality approach was being applied. So, for example, paragraph 77, one sees reference to the submission made to the Secretary of State. Paragraph 78, consideration of the Security Service assessment, again before the Secretary of State and before the court, subject to the PII redaction. Put another way, if one reads those paragraphs in their entirety, in my submission there was no further inquiry that the Divisional Court could reasonably have embarked on, even if one were to say that this was a case where a pure proportionality approach should be applied rather than either a rationality approach or a modified rationality approach, however one wants to describe it. For present purposes, then, my submission is that reliance on the approach urged by this court, for example, in Pham, that the common law approach should be informed by the tools of proportionality testing. It's simply an academic issue on the facts of this case. It is clear that regardless of the language that the Divisional Court used, the language of rationality, in fact, a proportionality-informed approach would make no difference because the court scrutinised all the material that was available, taking account, of course, of the effect of the PII application. Which
I suppose you're entitled to say that insofar as the appellant wanted to rely on any facts or wanted to put any facts forward, he had the opportunity to do so before the Divisional Court. And you, therefore, can take the facts as they are and say, if you can,
yes,
make good your submission, that whatever the test, even taking all the facts he's put forward,
yes,
there could only have been the answer which the Divisional Court gave, whatever test it had applied.
Well, that is right. But perhaps more centrally, if one considers the material that was before the Divisional
Well, that's what I'm talking about.
there would be no more material before the Divisional Court on proportionality if there were...
Well, one doesn't know, but it was up to him what he put before the court.
I was making the point by reference to the position of the Secretary of State.
Perfectly fair, yes, I see. Unless the court was there, yes.
Because the submission was there, the document provided in support of the submission was there. I appreciate there were redactions on public interest grounds, but that apart, the court had before it all the material it would have on, say, a standard Human Rights Act claim, and was in a position to scrutinise it. And one can see from its judgment, particularly from paragraphs 80 through to 83, that it did scrutinise that material.
And this is just an example of what Paul Craig has told us, which is that although we use rationality, we've actually been applying proportionality long before this court acknowledged it in Kennedy and Pham.
Well, quite, my Lord. As we say in our printed case, the Wensbury tools have always been sensitive to circumstances. There have always been either more intrusive or less intrusive levels of review, depending on the subject matter of the case. But
Like Monsieur Jourdain speaking prose, we were applying proportionality without realising it.
well,
That's really what Professor Craig was
Yes.
suggesting, that it was better to come
Come clean.
open and actually address.
Yes, I don't think Kennedy was a revolution. It was simply acknowledging what was already going on
well,
and what had been said by Lord Justice Laws and a number of other people.
well, respectfully, I would certainly adopt that proposition. And when you apply it to this case,
Yeah, I think.
well, one sees it makes no difference. Coming now to the second strand of the
Anthony Hughes to make a point.
sorry, the second strand of this last argument is the contention that there should be a merits-based review of the Foreign Secretary's decision.
Yes.
And this appears to be effectively that the court sits on the shoulders of the Foreign Secretary and decides for itself whether there were reasonable grounds to suspect, and so on.
Well, merits-based review is one of those slightly unhelpful expressions. I mean, in a sense, you could say there was a merits-based review in the Carlisle case,
Yes. Yes.
because that was under the human rights.
But ultimately, as I think it was your judgment, my lord, in that case, recognised that when it came to evaluating matters such as what would be the risk to British personnel in Iran, ultimately there were limits to the what the court could do.
I think I was in Lord Sumption's judgment, and indeed Lady Hale's and Lord Clark's, yeah.
So, but I'll precisely say there are
As well.
by reference to the way in which the submission is put. Firstly, it is said that this was the approach that the Court of Appeal recommended in Ahmed. Could I ask you to go to the Court of Appeal judgment in Ahmed, just to see what it was that Lord Clark and my Lord Wilson proposed. Firstly, in the judgment of Sir Anthony Clark,
Yeah. Where do we look? Which paragraph?
it is, yes, could I ask you to start at paragraph 111?
Can you give me a volume and tab?
I'm sorry.
Volume
it's
1 of the authorities.
Volume 1, tab 2, my lord.
Page 1265.
Thank you, my
Yep.
lord, yes.
Thank you. Yep.
111 is the submission for the Secretary of State in that course. And then, as was 112. And then 113, the question is whether the court is powerless to achieve a solution whereby a person in the position of G can challenge the underlying basis of the case against him. The question is thus whether he can do so through judicial review. If he can do so under the terrorism order, it would, to my mind, be very strange if he could not do so in the case of the Al-Qaeda order, in a case where the evidence against him appears to be the same in both cases. If he cannot, I would be inclined to hold that the Al-Qaeda order was unlawful. So, pausing there, the court had the two orders before it. The Al-Qaeda order, which had this automatic provision, if you were listed by the Security Council, you were subject to the prohibitions in the Al-Qaeda order. The terrorism order had a different mechanism, which allowed the Treasury to take designation decisions on the basis of reasonable suspicion that certain criteria were met. And Sir Anthony Clark's premise is that the position of a person subject to the Al-Qaeda order should be no worse than a position of the person subject to the terrorism order when it comes to the ability to challenge that decision. Now, somebody who was subject to the terrorism order would have a decision taken by the Treasury that there were reasonable grounds to suspect that the criteria were met, and that itself would be a prima facie reviewable decision by way of judicial review. And then continuing in the judgment, the conclusion is paragraphs 119 to 121.
Yes.
I would accept the submission. The court has the power to consider a claim for judicial review by a person to whom the Al-Qaeda order applies, and on such an application to ask the court, so far as it can, to consider what the basis of the listing was. This will not be a challenge to the order itself, but if, to take the example of G, it were held that G should not have been listed, I see no reason why the Treasury should not be bound to support delisting. And then 20, so far as possible in the circumstances, so far as possible in the circumstances, G should be put in the same position as he is as a subject of a direction under the terrorism order, with the right to challenge it under Article 5.4. And
Then he deals with special advocates and so on.
yes, and then my Lord Wilson's judgment at paragraph 157 on MS 1277, that judgment adopts the conclusions or the solution proposed by Sir Anthony
Really,
Clark.
the second sentence.
Yes.
I know it's very self-regarding to point to what one said oneself, particularly when it was all wrong. But, I mean, it was clearly an attempt to find a solution to the absence of any means of challenge.
Yes.
And what Lord Justice Law says was that we thought that was enough. The Supreme Court said that it wasn't enough, because to challenge within this jurisdiction the listing of the United Nations simply wasn't to focus on the real problem, and there had to be a wider mechanism of challenge. And so Lord Justice Law says, doesn't he, that what Sir Anthony Clark and I did in that case was to try to invent a problem, the solution to a problem, which has all been superseded by the Supreme Court's disposal.
Indeed, but my Lord, the important thing is that it was an attempt at a solution to the particular problem in that case. The position in the present case is very different. One is not faced with this decision by the Foreign Secretary, that is the decision that applies the preventative, the measures to Mr. Youssef. Rather, the Foreign Secretary's decision is at some stage removed from that. And so, in terms of, perhaps taking the matter by reference to the analysis of Lord Justice Law's in the Court of Appeal in this case, it's paragraph 41 of his judgment. If you're using the...
Page 212, 211, 212, yep, thank you.
In the core volume, yes. Lord Justice Law's analysis starts with the proposition that usually the courts do not engage in merits judgments on review of administrative actions. But then goes on partway through the paragraph. He says it follows a merits judgment in a judicial review case will be the exception. It will arise only where that is required in order to test the legality of the decision under review. Then he gives two examples. One is a situation where the exercise of the power depends on a question of precedent fact, which is not the present case. And then he gives the further example of proportionality testing under the Human Rights Act. But clearly there, by merits review, he is not suggesting that the court simply second guesses the decision maker. Rather, he is referring to a more intrusive standard of review that involves some consideration of the balance struck as a matter of the merits by the primary decision maker.
Well, the merits review is a review. It doesn't mean the court, however intense its focus, is substituting itself as the decision maker.
Precisely so, my lord. That should be the starting point in this case. Now, considering the decision of the Foreign Secretary, the first point is that it's not a decision that falls into the same class as the situation that was before the Court of Appeal in Ahmed. As I say, there, the decision under the terrorism order was a decision to apply restrictions to a person. The position under the Al-Qaeda order, equally, that order directly applied restrictions to the person. The corresponding measure in the present circumstances is Regulation 881.
I understand.
So, on that basis, there is no reason to approach the scrutiny of the decision taken by the Foreign Secretary in this case in the same way as the Court of Appeal in Ahmed approached the position of the person subject to the application of the Al-Qaeda order. in my submission is a complete answer to this part of Mr. Rotty's case. He referred in his submissions to the fact that Mr. Youssef did bring forward Human Rights Act claims, but the answer to that, again, takes you back to the nature and substance of the Foreign Secretary's decision in this case. That decision did not result in any interference with Mr. Youssef's convention rights. That interference only came later on the application to him of Regulation 881.
Understand.
When he was added to Annex 1. And so that itself does not provide any added basis for the court to apply a particularly intense approach to review in this case. So again, and finally, coming back to the decision of the divisional court in this case, and the paragraphs where one sees the approach of that court set out its review of the Foreign Secretary's decision. My submission is that there is nothing more that one could reasonably or properly ask the court to do by way of scrutiny of this decision. There is no special reason that would justify any further level of scrutiny by a court of the particular decision in this case.
Yes, I see.
My Lord, those are my submissions on the 4 grounds of appeal. The 2 other matters I need to deal with briefly. One is remedy.
Yes, of course. Does remedy arise, does that depend on the outcome of this appeal?
Yes.
Is it something that's better dealt with after we've decided, or is it something you think we should deal with now? I'm not. If it's something that's convenient to deal with now, then I'm certainly prepared to
So
consider it.
as you're suggesting that we shouldn't exercise a discretion to make an order consequence upon even a finding against you, it may well be that the reasoning is so intertwined with your suggestions that one should perhaps hear it now.
Yeah, but in a sense, that for the reasons
You deal with this at the end of your case.
We do, yes.
I mean, I'd like
Well,
to...
if you're wrong on any of these points, there'd better be a declaration.
Yes.
I think that's pretty obvious.
Why? Why?
you say that for the sort of reasons you've already been considering, plus what the delay, plus the finding of the ombudsperson,
Yes.
There should be no relief anyway in our discretion.
Yes, exactly. And so
Sorry, you're quite right.
go so far, if you feel it's appropriate, go so far as a declaration, but go no further in terms of no remission.
Why should
Well,
we
it's-
even go that
sorry,
far? I'm
Paragraph
sorry.
170,
Yeah.
it's accepted the appropriate order will be remittal.
Well,
Sorry, I don't
my Lord, I've considered the...
If the review conducted was inadequate.
Yes, I think the question of this form of relief arises if you are against me on the 3rd ground of appeal.
But why even on that? Why can't, I mean, if we got to that stage, what's the point of sending it back for the divisional court to exercise a discretion on 10-year-old information?
Well, that's the point I'm...
I mean, if there's a judgment to be made, a different judgment on a Kennedy-based approach, we could do it for ourselves.
Well, that's the point I'm trying to make now, that on reflection, although in the printed case, we said, yes, one would need, in principle, to remit the divisional court for further consideration. On reflection, taking into account the evidence that I drew your attention to yesterday, this was the 3rd statement of Mr. Scott in relation to how the application of a different standard of proof would not, in his evidence, have resulted in any different outcome for the Secretary of State, taking into account also the points that my Lord Commonwealth puts to me as regards to the age of this case, the decision of the ombudsperson based on new matters, that in those circumstances there would be no practical purpose served by sending this case back for further consideration. And so if your conclusion is that the Secretary of State erred in relation to the standard of review, clearly that would be stated in your judgment, and either that would be sufficient of itself, or it's something that could be encapsulated in a short declaration.
Yes, I see.
Can I put to you the more general point which I started with yesterday?
Yes.
I mean, why should we be giving any relief at all to this applicant? Because, I mean, as I understand it, he got, whatever the merits of his original listing, the Secretary of State decided that at a certain stage he should be delisted, and made extensive efforts to achieve that, was not able to do so. And eventually, the thing that really made it quite impossible was the fact that the applicant continued to put out very extreme statements, such as those given on page 929 of Appendix 2, such as the fruits of this martyr bin Laden and his good devout brethren, America will crumble thanks to these mujahids. I mean, this is what this applicant is saying, and he hasn't said that's not his position. And not surprisingly, given that, he's now listed and going to remain so, and the Secretary of State keeps that position.
Well, precisely so.
So why is more not being made of the simple fact that judicial review is discretionary and we're entitled to take account of the conduct of the applicant?
Well, my Lord, I do make that point, and I do say that the matters you've just referred me to simply underline that there is no purpose that would be served by this
Not just
litigation.
purpose, it's just something we shouldn't be contemplating at all.
Well, for that reason, yes. Well, can I finish by... You put a question yesterday to Mr. Otti about the statements and the position in the immigration proceedings. Can I just briefly give you some information in relation to that? The immigration appeal itself is listed for hearing next week in front of the upper tribunal. Evidence, the Secretary of State was given permission to put in evidence the statements referred to in the Ombudsperson's report. Translations of those statements have been provided. I think that for some of the documents, competing translations have been provided, but the differences between the translations, I'm told, are minor, and on many of the documents, including those that perhaps contain the most serious statements, there is no dispute as to the accuracy of the translation.
Now, that's about refusal of asylum, is it, Mr.
It is, yes. And in those proceedings, Mr. Youssef himself has not put in any statement that either denies or disavows those the statements that are now relied on by the Secretary of State.
Okay, thank you.
So that is the position in those proceedings. Well, unless I can assist you further, those are my submissions.
Thank you very much, Mr. Swift. Mr. O'Connor? Thank you. Mr. Otti?
My Lords, ground one first.
Yes.
Mr. Swift started yesterday afternoon with an assertion as to the factual premise for our argument under ground one.
Yes.
That the respondent was not aware
Yes.
of the torture-tainted nature of the proposal for the designation.
Yep.
And we, with respect, don't accept that as a characterisation of what has happened evidentially or in terms of argument in these proceedings.
Right.
It is inconsistent with the statement of facts and issues before the court. It is inconsistent with an express concession made to the Court of Appeal, and it's inconsistent with the evidence of Mr. Morrison. The statement of facts and issues is at MS 51.
Yes. Paragraph?
It's paragraph 16 towards the foot of that page, and it states in terms...
Sorry, MS
51.
51. Paragraph 16, yep.
The respondent was aware that the information that had been presented to the committee by the designating state in support of the request for the appellant's designation included evidence that had been or may have been obtained by torture.
Yes.
The Court of Appeal, consistent with that, at paragraph 52,
Page 215, yep.
The Secretary of State was aware, as Mr. Swift accepts, that evidence presented to the committee in support of the listing included evidence that had been or may have been obtained by torture.
Thank you.
And then, entirely consistent with that, if you go to Mr. Morrison's witness statement, which is in Appendix 2,
Yep.
page 696
Is that the...
of the appendix, page 885 to
Thank you.
886 of the MS numbers. You have paragraphs 20, 24 and 25 are the material ones. Paragraph 20 describes the note verbale and the list attached to it.
Yep.
with the express reference to the Egyptian conviction. Paragraph 24 refers to the list of names, including, again, reference to the conviction for membership of an illegal group. And paragraph 25 makes it clear that that list, referred to above, was put before the Foreign Secretary.
Including, presumably, the text at 20.
Including the text there. So it's unsurprising the concession.
It was not put.
Was not
Was
put.
not put.
Not put.
Not.
Other than the list of names.
Oh, I see. Other.
Yes, in support of the proposal.
So it's
not.
unsurprising against the
So the
background.
list included.
But wait a minute, this means the list of names was put, but the rest
Paragraph
wasn't.
20 says the list included the claimant in respect of whom it stated.
Yes, but
Yeah,
that
but
doesn't-
the 25 says that the information provided, other than the list of names, was not put.
Quite. So
So you had the list of names and nothing else.
Well, paragraph 24, if you read the foot of 24, page 696, the list of names included the following summary in respect of the
Yeah, but
claimant.
why does that show that the
Yes.
evidence might have been obtained by torture?
Yes.
Well, it shows that the reference is made to the conviction.
Yes.
And to be fair, the document, the note verbal, doesn't tell you much more than that. It just
No,
gives a bit of
the
details.
key documents.
Well, anyway, I see how you rely on what's said in the Court of Appeal and what's said in the Statement of Facts and Issues. I see why you're entitled to rely on that.
Well, it's actually very unsatisfactory to have a witness statement which appears to be the sole basis of evidence. And
One has the concession made by counsel on behalf of the Secretary of State in the Court of Appeal. I think Mr. Otty's
And my lords, the point,
entitled
one of
to
the
rely on
points we
that.
adopted before the Court of Appeal, and indeed the Divisional Court, was that the position in the light of Mr. Morrison's statement was somewhat opaque.
Well,
Therefore, we took some comfort.
I think if Mr. Swift wants to withdraw the concession which was recorded as being made in the Court of Appeal, he'll have to let us know whether he wants to, and if so, why. Because at the moment, I haven't discussed it, but it seems to me that concession having been made and recorded, you're entitled to rely on it.
Very well.
No-
And
till
in
it-
this
Court in the
Yes.
statement of facts.
Yeah, and in this court, you're entitled to rely on it unless and until Mr. Swift applies to be, as it were, released from it.
So whatever the merit of our legal arguments thereafter, we've at least got the factual premise for them.
At the moment, certainly. As far as I'm concerned, anyway.
The second matter referred to was the Scott statement, suggesting that the same outcome would have been arrived at by reference to balance of probabilities or
Yep.
reasonable belief. We respectfully adopt and rely upon the Court of Appeal's disposal of that argument of paragraph 22 of its judgment, essentially for the reasons canvassed in argument yesterday, that would be an unsatisfactory approach in a context such as the present.
I understand.
The next submissions made were as to the lack, as the Secretary of State would have it, for any reasoned basis for the designation in 2005 before a conclusion that the Bayer criteria were met. Now, as to that, we say that the Secretary of State's approach has failed to confront both evidence and material aspects of the resolutions. The evidence it's failed to confront includes the ministerial submission of 2009, which stated in terms that the designation was based on details of the appellant's terrorist convictions. I showed you that yesterday, but the reference again is Appendix 2, page 818, MS 1007.
Thank you very much. Yep.
There's a failure to confront the exchange of correspondence between the UK's ambassador to the United Nations in 2007, seeking to obtain publicly releasable information relating to the basis of listing. So acknowledging, we say that there was such a basis. Appendix 2, page 460, MS 649. And there's been a failure to confront, we would respectfully submit, the mandate of the committee point. The resolutions that we have drawn attention to in our 11th of November note make it quite clear, we say, that the committee is to act on the basis of information before it. The only three pieces of information which we know were before it are the three that I started with yesterday, referring to the conviction.
Yes.
The question as to the jus cogens obligation on the facts as we contend them to be,
Yep.
and the reliance that the Secretary of State places on the Binyam Mohammed decision of the Divisional Court. 4 points in relation to that, if I may.
Yep.
Firstly, the Divisional Court expressed the view, without having to decide it, that it may well be the case that Article 15 of the Torture Convention, the exclusionary evidence provision that we rely upon, reflected customary international law. That's paragraph 166.
Yep.
Secondly, the reason that Mr. Mohammed stumbled
Which
in
paragraph?
that...
166.
I'm sorry, 166.
Yep.
Secondly, the reason that Mr. Mohammed stumbled in that litigation by reference to that argument, we say, is not an obstacle to our success.
Right.
Because Mr. Mohammed was contending for a specific obligation of disclosure
Yep.
arising out of the general jus cogens erga omnes norm. In the present case, we are doing no more in substance than seeking to invoke the express provisions of Article 15 of UNCAT.
Understand.
Thirdly, insofar as the Secretary of State relies upon the Divisional Court's views as to the extent of interventionist obligations, the Divisional Court was at least prepared to contemplate that interventionist obligations might arise in some contexts. And importantly, we say the Divisional Court was necessarily proceeding at that stage on the basis of what we respectfully submit to have been the flawed understanding of the Court of Appeal in Al Rawi, then reflected in the Court of Appeal's judgment in this case, as to the significance of a norm being jus cogens.
Yep.
And you have the point I tried to develop yesterday, that Lord Justice Laws sought to limit the reach of the jus cogens principle by reference to a passage in Furenzija, which was actually dealing with the erga omnes principle.
Yep.
And the fourth and final point is, and this is picking up really on a point not referred to by my learned friend orally, but it's in his case.
Yep.
He says that the Divisional Court in Mohammed treated the House of Lords in A number 2 as having rejected, or at least not accepted, a submission that the exclusionary rule was part of customary international law. That, we respectfully say, is not a correct reading of
Okay.
the House of Lords in A number 2. Lord Bingham expressly found in favour of the appellants in A number 2 by reference to both the common law and the European Convention. And the appellant's submissions as to the common law had included a submission that it was customary international law that an exclusionary rule existed. And the references for that in the argument are 227F to G and 228H, and then the acceptance by Lord Bingham at 52.
Thank you. Yep.
Just dealing very briefly and in turn with the practical points that my learned friend sought to emphasise and which are set out in turn at paragraph 95 of his printed case.
Yep.
There's no difficulty in terms of a standard to apply in determining whether or not torture-tainted material should be excluded. It will either be the standard that the ombudsperson has identified and put before the Security Council, apparently without any dissent,
Yep.
namely, is there a reasonable and credible basis
Yep.
for the allegation, or it will be the standard identified in A number 2, sufficient to trigger the investigative obligation, namely, is there a plausible basis for believing?
Yep.
Secondly, reliance on torture-tainted evidence need not be exclusive. All that is required of the UK, we say, is that it cannot support a listing where torture-tainted evidence is potentially determinative.
Understand.
And thirdly, we say there is no difficulty in terms of knock-on consequences for a finding in our favour on this point because of the very particular nature of the 1267 committee and the exercise it is embarking upon. And this is our quasi-judicial proceedings point. This is a body which is purporting through its decisions to determine individual rights. It's purporting, at the behest, amongst others, of the General Assembly, predating this resolution, to adopt procedures which are clear and fair. And it has features redolent of quasi-judicial proceedings in the form of statements of case, evidentiary standards, and, albeit in relation to publication, after 2005, publication of reasons.
Yeah.
And we would say...
After 2008, that.
Yes, yes, that was 2005.
After 2005, as you say, but not immediately after 2005.
Sorry, yes, 3 years after.
Okay.
But, and our
Yeah,
point,
got the point, yeah.
got the point, my lords. So that I think is all I can seek to add on ground one.
Thank you. Ground two?
Ground two, Entick and Carrington, we also draw comfort from and rely upon the passage that my Lord Wilson identified in Lord Oliver's speech in the Tin Council case,
Yep.
to the limits on the prerogative.
Yes.
We maintain our submission, in the light of Mr. Swift's submissions, that the critical question is, how do you characterise the UK conduct in issue here? Is it properly characterised as involving an interference with ordinary common law rights of an individual resident in this jurisdiction or not?
Yes.
And notwithstanding the terms of Regulation 881, and indeed in reliance upon them, we say the conclusion must be that the answer to that is yes. We say it's artificial in the extreme to suggest any other outcome. There was no meaningful, substantive individual consideration given to the addition of my client to the European Commission Regulations Annex. It followed as a necessary and intended and inevitable consequence from the designation at the UN level.
Yeah.
It's contrary to the evidence that I showed you, which places all the emphasis on the 1267 Committee's designation, including the actual notification of asset freezing. It's contrary to the findings of the courts below as to the effect of designation at the UN level. And it's contrary, if one is focusing, as we do because of the narrowness of the dispute, if one's focusing on the question of has there been an interference with the common law right, it's contrary to the approach the common law takes to that question. Now, it's important to emphasise again in this context, perhaps in response at least partially to my learned friend Mr. Swift's point about, well, if you're right, then the Secretary of State's even now seeking an arrest warrant through proper channels would be acting unlawfully. But there's a material distinction here with that hypothetical situation, we say. And the material distinction here is that there is no independent exercise of discretion from the moment listing occurs at the UN level to the moment the EU measure applies. So even if one watered down the test identified in Davidson and M and recast it as involving a question whether there was any independent exercise of discretion capable of breaking the chain of causation, regardless of the extent of encouragement or support, we would still get home.
Yep.
Who enforces the? So is it the Home Secretary who enforces the freezing order? Who, in fact,
The Treasury, isn't it?
is the Treasury? Is it?
It's the Treasury, yes.
Yes.
Sorry.
Yep.
I mean,
It's a Treasury.
you've never challenged the Treasury action.
No, we haven't.
No, I mean, but you're nonetheless holding the Foreign Secretary effectively liable for the Treasury.
We are, in the same way as one authority was being held liable for the lawful acts of another authority in the M case.
Well, the Secretary of State is one person in theory, anyway.
Yeah. But I mean, the logic of your position, we go back over. Are you going to address the Morton's fork argument that I think is presented, namely that if this is all valid, then it's valid by reference to parliamentary authority through the resolution and through the European Communities Act. If it's invalid, then whoever is enforcing it is acting contrary to the law, and you ought to be attacking the domestic effect of the Resolution 881.
Well,
and those who are purporting to act under it in domestically.
I think the simple answer that the only answer we can make at this point is the fact that we have alternative targets and multiple targets we could be aiming at doesn't necessarily mean that our first target that is in issue here is a bad one.
It does mean that you've been submitting to something which you now say is quite inappropriate and illegal.
It means that we're saying that, well, yes.
I mean, you have been accepting that the freezing order is valid.
We have. And
yes, but the logic of your argument is that it's invalid.
And the question is, I suppose, in the end, whether there is more than one cause of the interference of which my client complains. And we say that the answer to that question is yes.
But if the key to the prison door is in the door and you're open to free to walk out, can you then complain that you've been wrongly imprisoned for years?
I'm not sure it's quite like that.
Well, certainly the threat of executive action has existed for all these years.
Yes, but you've never challenged the executive action. Anyway,
I don't think I can. I think all I can say, my lord, is as a matter of principle, the question is, did the act by the United Kingdom executive amount to an interference?
Yes.
And the fact that there are other operative causes of interference does not mean the answer to that is no.
Yeah.
Ground 3 and the question of standard of proof.
Yeah.
We say this is squarely within the domestic regime, albeit that it requires consideration of the resolutions. It's squarely within the domestic regime because the Secretary of State is directing himself that he will not support a listing unless satisfied that the criteria are met. He is aware when he's undertaking that exercise of the drastic consequences which will flow in terms of interference with ordinary rights. And we say against that background, he has to act in a proportionate manner, embracing within it the question whether what he is doing is necessary in response to the regime he's seeking to comply with.
Does this apply to any decision the Secretary of State makes in relation to the United Nations, say, which will affect people in this country, or does it only arise because it refers to a specific individual?
We would say we don't need to go further, certainly, than saying it only arises in relation to the specific individual, where a specific question is being asked, does this individual meet criteria?
Why should it only apply in that case? Where's the logic?
Well, I suppose logically, if there was a regime which allowed wider-ranging measures to be adopted by reference to a class of people, according to criteria, then the same argument would apply on my part. The Secretary of State should direct himself correctly.
So if it applies to any potential group of terrorists, or potential suspected financiers of terrorists, that would be, the Secretary of State would then have a duty when voting in a committee of this sort to take into account the sort of factors you've identified.
Well, the question, I suppose, well...
It would be susceptible to domestic judicial review.
We have invoked here the Human Rights Act as well, and we do have an individual resident in the jurisdiction here,
yes,
and property in the jurisdiction. And so there might be different questions which would arise if you take the example of any terrorist group anywhere in the world. They would
I'm talking about, obviously, people here. Yes.
If it's related to identifiable people here, then we say an entirely adequate domestic foothold is made out.
An identifiable group of people.
Yes.
That would be enough, I think. Okay. Thank you.
Now, there wasn't actually a great difference between us as to the test here. And the question was how it was met. And my learned friend's submission was that it was met adequately in the Secretary of State's favour by reference to the three matters he identified: the preventative nature of the resolutions, the urging of member states to comply with the task force recommendations, and the position of the ombudsperson now adopted. I think I've anticipated my submissions to some extent with those. Yes.
You're on ground 3 now.
Ground 3.
In relation to ground 2, do you have any submission to make about Hawani?
Oh, I'm sorry, my lord. Yes, I have got a submission on Hawani.
Really applying the Labrador principle.
Hawani is authority, as we read it, for the proposition that it is not open to a court to go behind what has been enacted by the legislature or to inquire how an enactment has come to be made.
Yeah.
And we say our case involves neither such inappropriate exercise. Our case under both grounds 2 and 3 is that there was no legislation authorising, let alone requiring, either the agreement to the appellant's listing or the application of a standard of proof as low as reasonable suspicion.
But the legislation in question will be the legislation of the EU, adding your client's name to the list of persons who are subject to a compulsory asset freeze.
Right.
And I see the analogy, my lord, in the light of that. And I think our answer then, probably to it, has to be driven by the engine of ground 1 and the jus cogens norm, that different principles would apply if the prohibition on that Hawani suggests is there on inquiring how enactment has come to be made involves a departure from a jus cogens norm recognised in international law but part of the common law and binding on the executive here, then it should not apply to that context. I think that's all I can say in relation to that. Ground 3.
Ground 3, yeah.
And standard of proof, the three matters: preventative purpose, a non sequitur, we say, for the reasons indicated yesterday. It doesn't determine a standard as low as reasonable suspicion, as held in Ahmed. Financial action task force guidance, again, raised in Ahmed, not held sufficient to sustain a test of reasonable suspicion.
Well, I had to look at that. I'm not sure. If you count the heads in Ahmed, it seems to me there's a difference in view. Lord Hope, with whom Lord Walker and Lady Hale agreed, plus Lord Roger.
Yes.
So that's 4 out of the 7. Either thought or accepted that the UN standard could be one of reasonable grounds, or left it open, depending how you read Lord Hope at 60. But he didn't decide the contrary, whereas Lord Phillips, Lord Brown and I expressed views about the scope of Security Council Resolution 1373 and suggested or said that it wasn't wide enough to cover a reasonable suspicion test. So on the face of it, there's no decision in favour of your proposition. There are at most 3 members of the court out of 7.
It's important for me to be clear about what my proposition is.
Yes.
And the proposition is that in Ahmed, the Supreme Court held that it was not necessary as a response to the resolution to apply a standard as low as reasonable suspicion.
Well, it wasn't expedient, we held, domestically.
Well,
and so wasn't within the United Nations Act.
Lord Hope, in terms, left open the question of expedience at 58, I think it was, but was clear, as we read him, that a measure like this was not necessary.
Well, the test of necessity
Just above,
derived entirely from the 1946 Act.
in context, that's absolutely right. The test
Where
of
does
necessity.
Where does she?
This is just above letter C on 58.
It was not necessary to introduce.
On which page? 628.
So
1320 at the bottom.
paragraph 58,
page
630 of the report, 1320 of the MS numbers.
Was not necessary to introduce. It may well have been expedient.
Just one line above letter C.
Yep. Thank you.
So we say that a majority has held, albeit, I fully acknowledge that, in the context of the 1946 Act,
Yes.
it is not necessary in the light of the resolutions, including the run of
So
resolutions.
you say he has held, but what the SCR means.
Yes.
Yes, I see.
So that's how we put that. As to the
But I mean, the difficulty is he then sets out the arguments by Mr. Swift in paragraph 59 that the reasonable grounds test was within the scope of the Security Council resolution, and he doesn't reject them, he recites them. And then at 60, he says, I don't think these arguments are sufficient to meet the basic objection to the use of the powers of Section 1 to impose the restrictions provided for by the TO on the grounds of a reasonable suspicion only. That's why I suggested that he hadn't decided the point.
well, he hadn't decided the expedient point
I see.
against the Secretary of State at that point, so he had to deal with it
I
somehow.
see. Yes, I see.
And we say he dealt with it by reference to the fundamental core argument that we seek to draw from this, arising out of the principle of legality.
But if it wasn't expedient at the domestic level, what's that got to do with the question what was permissible at the Security Council level?
The expediency point hasn't got anything really to do with my submissions. The submissions, if they work because of an equation between the concept of necessity in the 1946 Act and the concept of necessity as part of the proportionality analysis, which we say should be applied per Pham and Kennedy.
Yes. Thank you.
Just one reference on the special recommendations, one additional reference. The only paragraph of those interpretive notes to deal in terms with both resolution 1373 and the 1267 committee's position was that at 7H.
Page.
Excuse me, I lost my copies. Page 10 of the.
Sorry, which page of the bundle?
It's not in the bundle. This was the addition.
Oh, I'm sorry, I'm being an
Ended up
idiot.
by-
Yes, of course. Yes, thank you. Yep,
Page 10 of that document.
Thank you.
7H.
Yep.
And that deals with reasonable basis or reasonable suspicion in the context of 1373.
Yes.
But not in relation to 1267. But my main point here in response to this, my main 2 points in relation to these recommendations is that they weren't good enough in Ahmed, and in any event, because they contemplate both reasonable belief and reasonable suspicion, they don't render necessary
Yes.
the test as low as reasonable suspicion.
yeah.
The fourth ground of appeal and the standard of review and the question of whether the divisional court gave us a Pham Kennedy compliant review by way of anticipation and foresight. We say it's clear from the passages I showed your lordships yesterday that it did not. At paragraphs 47 to 59, the divisional court expressly rejected our case that there be a merits review.
Yes.
We had argued in our skeleton argument, the reference paragraph 46, MS, page 396, that if we were right and a merits review test was to be applied as to whether or not the criteria were met, then the answer on the challenge could only be in our favour, because the only evidence, direct evidence before the court, was a witness statement from my client denying any involvement in terrorism and rejecting all of the allegations made against him.
Yeah.
And no attempt on the part of the Secretary of State, through the deployment of any form of direct evidence, as would normally occur in the control order context through the mouth, for example, of a security service witness, to establish the contrary.
Yes.
And that is what a merits review would look like, we say, if it were occurring today.
Yep.
It would involve deployment of competing evidence. And now, and this is perhaps an important point to emphasise.
You better make it fairly quickly because you're way over
Yes.
time.
I'm
But
sorry.
yes, that's all right.
In fairness to the divisional court, at the stage of the hearing before the divisional court, there was no option of a closed material procedure by reference to the 2013 Act.
Yep.
That option would now be available
But
with
it wasn't
special
at the time,
applicants and
I
so
understand.
forth. Finally, very briefly, if I may, on remedy, and to address
Yes.
my Lord Commonwealth's points and concerns to the extent I can. In terms of the approach to take in relation to the views of the Ombudsperson, I would respectfully submit that the court should not, and it would not be fair for it to proceed on the basis that those findings are made out. That remains a question to be debated in the immigration proceedings, and that is the appropriate forum for them to be debated in. It may also be debated in a separate judicial review challenge to the decision to refuse to support delisting by reference to those findings. But neither party has approached this appeal on the basis that it should be putting in evidence to deal with those issues. So far as delay is concerned, and the extent to which that should militate against a remission, and this is an incomplete answer I gave to my Lord Sumption yesterday, or reflect an incomplete answer. The consequences for my client were not solely asset freeze and travel ban. They were also identification publicly and labelling publicly as an associate of Al-Qaeda, and so severe reputational damage. If, and it's clearly an if, the allegations in 2005 are not capable of being made out once a merits review is conducted, that is an exercise of real value to my client. My Lords, I'm very grateful for...
Sorry, you didn't comment on whether it's a review we could conduct ourselves.
I respectfully submit you can't conduct that.
Well, you've made that
yourselves,
point by
my Lord.
saying that the whole case wasn't proceeding on that basis.
Exactly
This appeal
so.
wasn't.
Neither party has proceeded on the basis that it should be engaging with those later findings or allegations in circumstances where the focus is 2005. So I was just about to thank the court for the indulgence it's given me.
Well, in a way, you should thank Mr. Swift, because if he'd taken his full time,
I'm happy to.
if he'd taken his full time, you wouldn't have been
I know,
given
my
the
Lord.
extra
So I
time.
do thank him for that.
May I just rise to deal
In
with
the circumstances, I think you may, yes, Mr. Swift.
It
Thank you,
is,
Mr. Otti.
Mr. Otti drew your attention to paragraph 52 of the Court of Appeal's decision and the statement that I made that's recorded there.
Yes.
My Lord, I do not seek to resolve from that. I apologise. I obviously I overstated matters yesterday. I apologise to the
That's
court.
very fair. Thank you. Thank you very much. Good. Well, we're grateful to you for getting through this case with its many facets, clear submissions. We are grateful also to all those who were involved in preparing the written cases. We will take time to consider our decision and let you know in due course. Thank you very much indeed. Court's now adjourned.